Hey guys, I hope everyone's doing well. I thought I would post a few things that maybe you've already heard about Sarah, of course, our wonderful suitcase Sarah, or if some I've heard call her Samsonite Sarah. And my understanding, they were supposed to have a hearing today, but it looks like they set it for tomorrow. I'm sure because I live in the weird, wacky state of Florida where all these weird, wacky, and sometimes horrific crimes occur. And, of course, hurricanes. But we are so far lucky. We're just having some wind and rain. I was out today, Thursday, and we'll be out tomorrow. The school where I work is used as a shelter for someone who may need it, so no school till Monday, which is good because I need a little bit of rest from those children of the corn. But it looks like, as I was looking on the docket and all that, it looks like it's scheduled for tomorrow. So I'm assuming maybe it's due to the weather. But like I said, so far, so good. The lights have flickered, but that's nothing. As one person posted a meme that says something to the effect of only people in Florida who live in Florida would understand that it's not the strong winds or the rains or the flooding. It's not having electricity and sweating like a pig. I mean, to a point that is true. It's probably exaggerating a little because if I lived on the coast, that would, but yeah, it is kind of, I don't like to sweat. And I don't know, I'm a native Floridian, but I'm always hot. I need to probably move up in a more northern area. But anyhow, I feel very lucky, although I know a few friends that live not far from me lost their power for a little bit, which is crazy. I mean, but it's just kind of dark, and hopefully I'll get through this. But neither here nor there. I was going to just share a few things with you that came up. This was filed on the 23rd from the prosecution. It says notice of supplemental discovery. So this is, yes, the assistant state attorney. It says comes now the state of Florida. Let me move it up here. By and through the undersigned assistant state attorney, and hereby makes the following information available to the defense and state as follows. Number 1, Abraham Moreno gave a statement to law enforcement in this case, which has been provided in discovery pages 237 through 247. Number 2, the undersigned assistant state attorney spoke with Mr. Moreno in advance of trial on September 23rd, 2024. Number 3, Mr. Moreno indicated to this ASA that the defendant was stating that what happened was an accident on the day of the M. Mr. Moreno said that the defendant stated that she was teaching him a lesson and things got out of hand and that she fell asleep. Mr. Moreno recalls the defendant making this statement prior to law enforcement arriving on scene. So, I guess maybe he'll be a witness for the state. Interesting. So that, that just keeps, canceling out this nonsense that Sarah is trying to say it was in self-defense. Well, first the battered spouse, and then it was in self-defense, and I don't know. But then there's more drama. There was more drama because remember when in the last video I was talking about the Miranda right thing and all that? Well, y'all may have already seen this too. Like I said, I'm always a little bit behind. And by the way, I'm not very formal here, but if you're new here, welcome. This is a very laid-back place, and hopefully you find it a warm and welcoming place. And I'm not a psychiatrist, psychologist, lawyer, paralegal, just someone who is interested in true crime and wants justice for the right people, and just nosy, because some of this stuff is just downright soap opera-ish. You know what I'm saying? So there's that. So I'm going to pull up what now Mr. Owens has filed, or his motion. So this was filed on 9/24. So it is motion to suppress defendant's statements at OCSO, Orange County Sheriff's Office. This is rich, let me tell you. Comes now the defendant by and through the undersigned attorney pursuant to Rule 3.19 Florida Rules of Criminal Procedure, the 5th and 6th Amendments of the United States Constitution, and Article 1, Section 9 of the Florida Constitution, and respectfully moves the court to suppress all statements made by the defendant during her interrogation at the Orange County Sheriff's Office, and in support thereof states as followed. Number 1, the defendant, Sarah Boone, is charged by way of information with a single count of second-degree M. Number 2, on or about February 24th, 2020, the defendant called 911 in response to finding her boyfriend, George Torres, deceased. 3, Deputy Kayla Rodriguez of the Orange County Sheriff's Office arrived on scene with her body cam activated. Deputy Rodriguez spoke to the defendant and realized a D had occurred. Deputy Rodriguez advised her superiors and secured the scene. Number 4, sometime later, homicide investigators Chelsea Conley, aka Chelsea Copesel, and Scott Lowen arrived. These 2 investigators would ultimately be responsible for this homicide investigation and were involved in the interrogation of the defense at the OCSO the next day. Number 5, the defendant was ordered to remain on scene while the OCSO conducted their investigation. The defendant stayed outside of her apartment for approximately 14 hours during this time. Number 6, at some point, the defendant was asked to get into a vehicle with Detective Copesel and Detective Lowen. Once inside, Detective Copesel recorded an interrogation with the defendant after partially reading her Miranda rights, omitting the final question. And I believe that's the same thing that she did on the one I went over the other day. The defendant was advised she needed, if the defendant was advised, this recorded interrogation was routine protocol and official procedure for any investigation. Well, that's true. Okay, number 7, during the investigation, Detective Copesel asked to see the defendant's phone. The defendant complied and gave her phone to the detective. The defendant was asked to unlock her phone, and she complied with the demands of the lead investigator. Number 8, after Detective Copesel had the defendant's phone for a period of time, she came back and told the defendant that she was taking the phone. Detective Copesel asked the defendant to sign a form releasing it to the OCSO for further investigation. The defendant acquiesced to authority and signed the form. Number 9, the defendant was told that one of the detectives would return her phone to the defendant at her apartment in Winter Park the following afternoon. Number 10, later that evening, the defendant moved to her ex-husband's home, Brian Boone, for the night. Using her ex-husband's phone, the defendant called lead detective Chelsea Copesel to express her concern that Detective Copesel was not being truthful about law enforcement motives as it relates to the defendant. The defendant told the detectives she believed they were trying to trick her. Number 11, the detective assured the defendant that they were not trying to trick or implicate her, but the following day, the defendant needed to drive to the Orange County Sheriff's Office to retrieve her phone. The detective explained that the reason for the change in plans was because she was pregnant and not feeling well. Number 12, the next day, February 25th, 2020, the defendant arrived at the OCSO to retrieve her phone and had questions about this tragic event. Yes, her list of questions, her papers. Number 13, while still under the impression that she was retrieving her phone, Detective Lowen led the defendant upstairs into an interrogation room. A custodial interrogation ensued. Immediately after the interrogation, the defendant was arrested and charged with the offense above. And then number 14 says, this approximate 2-hour interrogation was recorded. Number 15, the initial dialogue between Detective Copesel and the defendant Sarah Boone. Detective, I'm going to have you sit in the green chair. Detective, appreciate you coming in. Sarah Boone, yes ma'am, and I want to ask about these whenever you have a moment, referring to her handwritten notes. I'm going to add handwritten notes with questions. And the detective says, sure. And then detective says, so obviously he received his autopsy. Detective, so I'm going to read you your rights again because we have to talk about that. And he puts it in bold, like she goes, we have to talk about that. I didn't feel like, excuse me, in my opinion, the detective said it quite so ominously, but hey, whatever. Detective, and we're not done talking about the incident. And then detective, we just have to do it. Sarah Boone, just like we did yesterday. Excuse me. Sarah Boone, normal protocol. Detective, just like we did yesterday. Detective, remember I read you the rights? Detective, yeah, it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay? Detective, so you have the right to remain silent. Anything you say may be used against you in court. You have a right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? Sarah Boone, no. Detective, and do you understand what I just read to you? Sarah Boone, yes. And the detective says, perfect, okay. Detective says, so this morning we went to his autopsy and we were informed of some injuries he had by the doctor. Defendant says, where? Let's see, I'm sorry, I lost my place. Okay, where? And then the detective says, so he's got scratch marks to his back. 16, the interrogation continued for approximately 2 hours. At the end, while still in the interrogation room, the defendant was placed in handcuffs and arrested. The detective read the defendant her Miranda rights directly from the printed card of the OCSO. The detective omitted the final question printed on the standardized Miranda card at the Orange County Sheriff's Office. 18. The detective omitted the same Miranda rights question that she omitted the day before. 19. The omitted final Miranda rights question is, having these rights in mind, do you wish to talk to us now? 20. The defense has yet to receive a true and accurate copy of the Miranda rights card from the Orange County Sheriff's Office. Number 21. Upon information and belief, it would look something like this. Excuse me. Okay. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you are being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. And then there's the waiver that the detective omitted both times. Do you understand each of these rights I have explained to you? Having these rights in mind, do you wish to talk to us now? I think she said, do you understand each of these rights? I don't know. I could be wrong. I think the one that she left out was, having these rights in mind, do you wish to talk to us now? But neither here nor there. Apparently, she did leave it out twice. So it says next, based on all the circumstances surrounding this interrogation, the defendant's statement was coerced and not freely and voluntarily given. The defendant did not freely and knowingly waive her rights under Miranda. Number 23. As such, the entire 2-hour interrogation should be suppressed. Okay. Wherefore, the defendant requests that pursuant to Rule 3.190 Florida Rules of Criminal Procedure, the Fifth and Sixth Amendments of the United States Constitution and Article 1, Section 9 of the Florida Constitution, and respectfully moves the court to suppress the oral statements made by the defendant during her interrogation at the Orange County Sheriff's Office on February 25th, 2020. Well, what do you all think about that? Now, just to be sure, I would definitely have the card and read it word for word. Excuse me, I'm just closing this door here. Because any of y'all who followed that horrible Chad Dorman case when he unalived his precious 3 little boys in Ohio, but now he has, what did he do? Oh, I know, he pleaded guilty, but got a deal not to get the DP. He confessed, oh my gosh, everything. He's confessed to the police, but it got to be tossed out because there was at one point, it's a little different than Sarah's case, but there was a point in there where I think he said something about a lawyer and the police did not continue on, so they actually got it thrown out. So while I could say it's a possibility, I don't know how they could throw out the whole thing just because they left out that one part. Now, I did watch Lawyer, with Peter. And he he said the same thing. They should just, to be sure, just read the dang card, Look at the card, read it word for word so there's no questions. But he doesn't think that it will fly. Could you imagine if they just erased the 2 hours that she was in there saying over and over again? And the one thing he said is that, he said one thing he would say for the defense is he wished he would have related to some sort of case law or something like that about the Miranda warning. And he said maybe just because, he said understandably so, he is extremely rushed because he really doesn't have a lot of time and the clock is ticking and all that kind of stuff. But he said, and all that kind of stuff. But he said that that would have been a better legal argument. But according to him, he feels like it will not all be tossed out. I mean, would that be crazy? because the Chad Dorman thing, they did mess up. There was a part where he did say something about an attorney, and they didn't believe him. But man, you know, you got to be careful with this stuff. And the thing was, Sarah was very willing to give her phone. She had her handwritten questions that she'd brought in. And I really, again, you know, she offered them all kinds of information and said it wasn't intentional. You know, it wasn't on purpose. They were just playing. It had been a good day, yada, 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 blah, blah, blah. But I just can't, excuse me, imagine that the judge would strike all of that. But would that be crazy? Wouldn't that be crazy if he did? Of course, they still have the suitcase video. That's probably that's all they need at that point. But you know, but they're going to have this other person. It's interesting now that the state is going to have this person come in and probably be a witness and relay what Sarah told him, I believe it was. So what do y'all think? Do you think the judge will strike all of that 2-hour interrogation part of it, or none of it? So seeing this made me feel like, okay, they must have decided to hold the hearing tomorrow due to the weather situation. Because of this thing, it says, order on defendant's motion to appear via Zoom. This cause having come before this honorable court on defendant's motion to appear via Zoom, and this honorable court having reviewed the same and being otherwise duly advised, and the premises it is ordered and adjudged that defendant's motion to appear via Zoom is hereby granted. Defendant's counsel James Owens, Kevin Beck, and Tony Henderson are allowed to appear at the Trial Management Conference on September 27th at 2:00 p.m. So, according to that, it should be tomorrow at 2:00 p.m. Eastern Time. So, hopefully they'll address all of these things that these motions and everything. Okay, guys, I don't know if you remember a while back I had talked about there were some things on Sarah's docket about the last 3 attorneys that represented Sarah Boone were wanting more money. I'm sure due because she's such a pain in the ass. Mr. Bankowitz, Mr. Hobson, and Patricia Cashman. And so, and I know people are probably saying, where's Judge Cranick? Well, this judge handles this. Her name is Lisa. I think it's Munyon. I'm going to say Munyon. But anyhow, this is about 15 minutes. There was another one that was much longer, but this one, the audio is much better, and you actually can see most of the attorneys where you couldn't in the other one. So it's a win-win. So I didn't really read all the paperwork to y'all because I thought, well, I don't really know a lot about that kind of stuff. But I thought, well, if they're showing the video with them in court trying to get their, I'm sure their rightful pay, then we can share it. It'd be easier, to explain and see what they say about Ms. Boone.
Thank you on behalf of Ms. Boone, Judge. I believe I said in my notes that attorney number 7, but I think I was actually attorney number 6 on the case. I've had the case the longest of the 3 of us that are appearing before the court now.
All right, thank you. And Mr. Hobson, you were court appointed to Ms. Boone at some point during her saga as well?
I love it, saga.
Yes, Your Honor. After Mr. Bankowitz withdrew, I was appointed.
All right. So we have all 3 of your bills, and I know JAC had indicated they had no objection to Ms. Cashman's bill, but I did not get a similar statement with regard to Mr. Bankowitz or Mr. Hobson, so I thought I needed to have a hearing with all 3 of you present. I am... Mr. Lake?
I was just saying, there is an objection here because essentially where we're at this point if this is compensation and it sets the flat fee because there's 3 attorneys involved. So there's no line item objections per se because these are all flat fee bills, but we're basically objecting on the basis that the total compensation here is going to exceed the flat fee to some extent.
Right. And I will tell you that I am very familiar with Ms. Boone's case because she has gone through many attorneys and has, according to Judge Kranick's order, sabotaged those relationships. And accordingly, attorneys needed to withdraw and new attorneys were appointed. And I do recognize that a lot of work was done for Ms. Boone. So we will start with Mr. Bankowitz, then move to Mr. Hobson, and then to Ms. Cashman.
Thank you, Your Honor. Basically, I had the case for a little over a year.
Oh,
I
poor
had
man.
175 hours in the case, including actually 45 hours at the jail with the defendant. When I received the case, I got a box of crazy information, I'll put it that way.
Crazy information.
And it was an entire file box, and it took weeks to go through it, categorize it, and kind of figure out what was going on in the case at that point in time. She originally had a privately retained attorney, and I basically received his case and his file because all of the other court-appointed attorneys before me, I believe, had waived any attorney's fees, and because they did basically nothing on the case. The 3 of us did a lot of work in the case. As I said, I put in 175 hours, and even at the $75 an hour compensation, we're looking at $14,000. Spent a lot of time with Ms. Boone and a lot of time in the case. So I'm requesting a flat fee in this case.
All right, thank you. Mr. Hobson.
Good morning, Your Honor. Good morning, everyone. Your Honor, I got the case from Mr. Bankowitz, and I got the same information. The information Mr. Bankowitz just recited that he had and reviewed, and in addition, of course, his information on top of all of that. I spent some time with the defendant at the jail. I spent a tremendous amount of time with the investigator reviewing the case, talking about discovery, experts, and so forth. I spent a tremendous amount of time with a proposed expert, Dr. Linda DeRay. It turns out the defendant didn't like her. I thought she'd be great. We talked for dozens of hours, almost daily.
So Sarah didn't like the expert he brought in because Sarah knows best. Wow. See, I kind of like this. We're really getting the scoop on Sarah from these attorneys that had to deal with her.
Periods of time coming up with theory of defense or theories of defense. In fact, you combine the information from the expert, the first attorney that was privately involved and took the case right up to the edge for trial and then had to back out. So I had that information, those boxes or box of information Mr. Bankowitz talked about. I had those, I had to go through those. I gave all that material to Ms. Cashman plus my information on top of that. Spent a lot of time interviewing people about how they'd respond if they were jurors. So I was looking at the case from all of those. I had the case from, I believe, September 23 until May 24. I would say conservatively, any lawyer that had this case can tell you easily they spend at least an hour to 2 hours on this case every single day. Getting the information coming in from Ms. Boone, the matter she wanted dealt with, her theory on the law, versus our theory, and it was a constant.
Hear that? Her theory in law versus our theory in law. Her telling them what she thought they should do. So what is the difference with her and Mr. Owens? I guess the fact that he has two other attorneys and his two assistants, but I don't. I have no idea. Maybe we'll know. Maybe we'll never know the reason why Mr. Owens took this case.
Battle going back and forth. You had to deal with the gaslighting.
Gaslighting,
and,
yeah, I believe it.
I told Judge Kranick at the time that I withdrew that it just was too much. This case required at least 2 lawyers. I told that to Judge Kranick, plus possibly an assistant. I see now the case has 3 lawyers.
That's right.
Experts that we worked at getting, plus investigators. So everything they're doing now, we attempted to do. We made every effort to do all those things. Miss Boone now has custody of files belonging to myself, Ms. Cashman, and Mr. Binkowitz. We did just put in a tremendous amount of work. It taxed every fiber in your body and the bodies of the assistants or any.
It taxed every fiber of the body. It's not surprising.
Person that worked with you on this matter, and I think flat fee for each of the attorney would be exceedingly reasonable, Judge. And I heard the judge comments regarding $75 an hour. I won't even speak to that. It would be totally redundant given the expert knowledge of all the attorneys and Your Honor involved in this case and any other case we come to the court on regarding fees. But this was a extremely difficult case, Judge. Most of the difficulty revolved around just handling the defendant and coordinating the defendant's thoughts on how things should go with what our experts were telling us and our investigators were telling us. So I believe the flat fee for each attorney would be anything less than a flat fee would be totally confiscatory, Judge. Thank you so much.
Thank you. Ms. Cashman.
Your Honor, I'm asking for the $15,000 flat fee, and I'm also asking to be reimbursed for the $1,800 that I paid to an expert, and JAC has a copy of my check front and back on this case. One of the issues that always has to be addressed when there are multiple attorneys, and I was the 8th attorney and the 4th private court-appointed attorney, is making a case that is old by purposes for reasons of being on the docket for a long time a priority and putting aside other work. One of the unusual things about Miss Boone's case was when I did withdraw for ethical reasons, the court found that she had forfeited her right to an attorney. She is charged by information with second-degree murder. There was an unusual amount of media attention on this case. The facts are she's accused of putting her boyfriend in a suitcase. He later dies. There is a video of this that went viral. Because the video went viral, because of coverage by Court TV, News Nation, Fox, the local channels, the Sentinel, and websites such as Know Your Lawyer, Legal Bites, and Bruce Rivers, you had to review not just the banker boxes of discovery and work done by the previous attorneys, but stay up to date with what potential jurors were viewing if they were watching it on the internet. There was a lot of correspondence between the defendant and the court. Obviously, had to review all that.
Oh, God, yes.
Most recent piece of correspondence when I was Ms. Boone's counsel was the 58-page letter that she wrote. And again,
Lord.
all these letters are published, they're analyzed. I, like previous counsel, spent an inordinate amount of time with Boone. I spent over 20 hours during my period of time that I was representing her. I believe that for multiple reasons, the court can find that this case was extraordinary and unusual, and that it would be confiscatory to not pay me the flat fee. And having provided the requested proof based on the procedure for reimbursable costs, it's my understanding that Mr. Lake is not objecting to me being reimbursed for the $1,800 that I spent to retain an expert who did not have a contract with JAC.
Thank you. Mr. Lake.
Yes, Your Honor, just briefly. As far as the issue of the $1,800, JAC has no objection to that reimbursement. That's more of a technicality. The court did approve the expert. This is just the attorney getting reimbursed for expense that we have no objection to. So that's a non-issue. We see that in the order. As far as the fees are concerned, the issue here is that other than Ms. Cashman, who submitted an hourly statement of 118 hours, none of the other attorneys actually submitted hourly statements, so we are kind of constrained by the statute. The problem is the statute only allows us to 200% of the flat fee in the absence of hourly statements. In other words, the way that the statute is worded very unusually, but essentially what it says is the court can award up to 200% of the flat fee without, and then it can only go above that if it finds that the case is confiscatory, and then can compensate the attorneys at a rate of $75 an hour. So that's where we get into a little bit of a difficulty here, because double the flat fee here would be $30,000, which is less than each of the attorneys. If you're requesting $15,000 each, it would be $45,000. And as far as, and at that point, looking at the statute, what we have is, Ms. Cashman, she got 118 hours in. That would represent a rate of $75 an hour, $8,850. Based on Mr. Bekowitz's statement, he has 175 hours in, which would be $13,125 at that rate. And Mr. Hobson, he just basically said about 200 hours, which would be $15,000. That's the issue, Your Honor, is that, I mean, technically compensation has to be at a rate of $75 an hour for it to go above $30,000. And so beyond that, I mean, ultimately, but you leave it to court discretion to determine reasonable fees for each attorney, and we acknowledge that this, I don't think we can even begin to dispute that this is not an extraordinary unusual case. It's just that what the statute says is how the compensation structure is set up, and we have to argue that the court needs to follow that structure.
Mr. Lake, if one bills hourly, can the others be flat fee under your interpretation of the statute?
Until you get to double the flat fee, yes, that works. But once you go above double the flat fee, then at that point, it really should be compensation, should be $75 an hour. However, we also acknowledge that we have had other cases like this where the court has awarded the full flat fee to each attorney, and we've never taken it up. So, I mean, it's essentially, we have to argue that you can only go to 200% of the flat fee, and at that point it has to go hourly. But we also acknowledge that realistically, there is no attorney on the case. Other than somebody who might take the case pro bono for other reasons, there's no attorney on the surface of this planet that would take this case for $15,000.
Your Honor, if I may address.
I don't need to do that, Mr. Hobson. Thank you.
Yes.
I am going to award the $15,000 flat fee to Mr. Bankowitz and Ms. Cashman, and a $15,000 hourly fee to Mr. Hobson. Ms. Cashman will be reimbursed her $1,800 in costs. I will issue an order to that on each of these cases. You've sent me orders electronically, and I will e-sign them. I've got it here, and e-file them in just a moment. Mr. Lake, do you have any questions?
No, Your Honor.
All right. Anything further with regard to this matter?
No, Your Honor. I would just state that I'm not asking for this cost, but I paid over $400 in photocopy
fees, costs for material that I sent to Ms. Boone along the way. But I'm not asking for that to be refunded to me.
All right. Thank you, Mr. Hobson.
So I just hopped over to the court notes online. And although this is, each attorney had their own separate paper, but I'm just using this example for Mr. Hobson because it's kind of saying what they all had to put into it. And so they're saying, well, at the top, I don't think, let me see, it says order approving reasonable attorneys' rates. So it's saying, this matter having come on before the court on motion to set reasonable attorneys' fees pursuant to section 27.5304 filed by attorney Winston E. Hobson. Okay, so I'm just using his as an example of, because it lists all what they had to go for. So I'm just going to skip over. It says, number one, they find that the fees as set forth below are appropriate and reasonable, and that the fees are incurred as the result of representation in this case, which is unusual and extraordinary, and therefore merits compensation exceeding the statutory limit in accordance with Macomson versus Martin County. Number three says that 200% of the flat rate for all the attorneys in this case would be confiscatory. Lost my place. Confiscatory. Okay. Therefore, counsel is to be paid the rate of $15,000 for the case in issue for 200 hours of billable work. 4. Because of the length of representation in this case of multiple attorneys appointed, the volume of discovery, the witnesses, the depositions that had to be taken or reviewed, and the and the complexity of issues, counsel is seeking the flat fee. The case involved voluminous pages of discovery, numerous photographs, numerous videos, numerous hours of recorded statements from defendant and several witnesses. Let me move this up in case I'm reading it before you get to see it. Sorry, let me move it up. And I'll have to find my place. Sorry about that. Yes, voluminous, numerous videos, numerous hours of recorded statements from defendant and several witnesses, hours of jail visits with the defendant, numerous videos of the alleged criminal episode, review of expert witness material, tremendous number of letters from the defendant, reviewed and research of issues, numerous conferences with the investigator and expert witness. So there you go. That's why all that stuff is granted, because basically they're saying Sarah is difficult, a narcissist, and a pain in the ass. Of course, again, you know, I'm not a psychologist, psychiatrist. That's just my opinion. But I thought I'd get you all up to speed if you weren't already, or at least give you my opinion, because everyone's is a little different, right? And hopefully we will see this next hearing come to fruition. I can't even talk fruition tomorrow, and we can talk about that. But in the meantime, I just want to share this and give you my opinions on this stuff. Okay? Thank you all so much, as always. I love you all. And be kind to someone, be kind to you, and I'll see you the next time.